Welcome to the Military Justice Today podcast with your host, Robert Capovilla and Mickey Williams, covering the full range of military law topics from all branches of the armed forces. Today's episode is made possible in part by the law firm of Capovilla and Williams. And now, let's welcome the hosts of the show, Rob and Mickey.
All right, everybody, here we go. Another episode of Military Justice Today. I'm Matt Starosiak, sitting in the studio today with none other than Robert Capovilla. Hello, Robert.
Hey, Matt. How you doing?
Yeah, I'm doing great. How you doing today?
I'm wonderful.
Yeah, good. Well, let's get into our pre-show topic. We've got a great episode. We're going to talk about some military rules of evidence that you believe are very, very important in the practice of law that you guys do at Capovilla and Williams. But before we do that, I want to ask you something about military recruiting numbers. We got a report out yesterday, and these episodes, as everybody knows, they don't always come out right after we record them. But we got a report yesterday that talked about military recruiting numbers being way up in December. But I'd like to get your thoughts on it, which is, are you surprised that the numbers shot up in December? Do you anticipate them continuing to climb? And do you think that is a Trump factor, or do you think that there's something else at play?
I think it's a Trump factor, and I think it's a Pete Hegseth factor. I really do. Under Biden, as an individual like myself who works with the military every day, and folks always want to talk to me about the military, whether I'm at a restaurant or the cigar bar or whatever, they ask my opinion like I'm still in. And I noticed a serious, when you work with military folks and veterans like I do every day, like we do every day at Capovilla Williams, there was a lack of confidence in the commander-in-chief about the direction the armed forces were going. We got a lot of complaints about DEI, and our war fighters were spending days in the classroom learning about DEI and sexual harassment and all this kind of stuff, which, that's fine. But at the end of the day, I think that there was a belief that the Biden administration was placing far too much emphasis on areas that did not help us actually win and fight wars.
Yeah.
Which is, by and large, Matt, why people join.
Yeah.
You're going to have Mickey Williams and Dan Higgins in here later today talking about some different military topics. Ask those guys why they wanted to join. And they were both decorated Army Rangers. And they're going to tell you, well, because I wanted to fight bad guys. I wanted to jump out of airplanes. I wanted to shoot weapons. I wanted to do the stuff that soldiers do. When I think under Biden, we saw a shift from that, where the young guys like Dan and Mickey at one point, they're probably now looking at the military, not even identifying it. Like, wait a second, I have to have all this training in DEI and transgender relationships. And that's not, for most people that want to join the armed forces, that's not what motivates them. And so I do think we're seeing an uptick because of Trump and because of Hegseth and because of a emphasis being placed on, let's actually support the warfighter. Let's make sure we're a lethal force first and foremost. And part of that, there is some validity to strength and diversity. The Army, the armed forces, Matt, has always been a place where minorities could come and get a better life. If you look at the history of the armed forces and civil rights reform, the armed forces were always ahead of the times. I don't agree with Pete Hegseth when it comes to women in combat. If you look at what women snipers did in Stalingrad in fighting the Nazis, incredible combat record. But I do think that the idea now that we can be proud again in our military, that we are going to be focused on lethality and doing the things that the military is really designed at its heart to do, I think is why you see an uptick in recruiting.
Yeah, that's interesting. I agree with a lot of what you said. I think that, there is a reason why folks sign up for the military, and it's to do those things you're talking about. And frankly, it's to kill bad people. I mean, that's what some folks are signing up for, if not all. And the further you get away from that, I think I've always said nobody takes things to the extremes like Americans do. We'll take a good idea, maybe DEI is a good idea at its core, and then we turn it into something that is so far from what it should be, and it starts to turn people off, and it gets this momentum and snowball effect. And we see it with all kinds of things. We see it with Black Lives Matter. We see it with defund the police. It's like there's something that needs to be done, and Americans will just take it, to the extreme.
Right.
And then the next thing you know, the people who initially supported it and who would go for the idea that, hey, this does need addressed, it does need improved, they're all of a sudden turned off by it.
DEI at its core is very valuable, right? We should absolutely respect people of different races and genders and sex and all that kind of stuff. And the Army should be a reflection of America, and America is a diverse country. That being said, when the social impetus or DEI becomes the reasons people are promoted, then we have a problem, right? We should be promoting the best and the brightest at every level of our armed forces. And that shouldn't be dependent on, are you a black man or a white man? Are you a male or are you a female? Are you a transgender soldier or are you not? It should be, are you good at your job?
Yeah.
Are you qualified? Are you a leader? Are you courageous? Do you support the Army values? That's where the Army in particular got it wrong. It went so far to the left in terms of promotions that we started seeing, and I saw it with my own eyes, Matt. It's one of the reasons I got out of the reserves when I did. People were being promoted for reasons that had nothing to do with performance. And we're never going to get it right 100%. But in this country, the best, the brightest, the most dedicated, the most hardworking should be the ones who get promoted.
Yeah.
Call me crazy, but that's what I believe.
Well, I agree. And I think, physical attributes, that's probably a different topic for a different day, but those matter too. Yep. Especially when you're talking about things like combat and protective details and things like that. You and I aren't the tallest guys in the world, right? We're just not. We're not blessed with that. There's certain things that I would expect that would disqualify me from, right? There's certain jobs that because I'm not 6'2", that I probably shouldn't have. I'm also colorblind. There's certain things that I can't do because I'm colorblind, and that's the way it is. But we were getting so far away from the idea that because you have a physical attribute or because of XYZ, you can't do this job, so we're going to force you into it anyway.
Right.
It just, it's too big of a jump for a lot of people.
The standards matter, and the standards are in place for a reason. For example, the ARTB, to graduate from Ranger School, you have to pass a very difficult physical fitness test. You have to do a lot of things that require extreme physical fitness. I don't think those standards should be adjusted because those standards are in place to ensure that when you're in combat, not only can you confront the enemy, but you can also take care of the guy next to you.
Yeah.
And so if women can do that, great. I'm all for it. But it's got to be the same standard.
And it matters. I mean, we shot a video with Dan Higgins from the firm, former Army Ranger and sniper team leader before, and he talked about combat situations where they were running upstairs with, 80 pounds of gear and sniper rifles and weaponry. And he said, some of the guys struggled, man, and we were having a hard time. And it does matter. It's not make-believe. It's not a hypothetical situation. It's real world shit when those guys are out in the field and something needs to get accomplished.
You're talking to a guy who, unlike Mickey and Dan, did not want to do some of the things in the Army that they did. And not only did I not want to, go to Ranger School when I recognized how freaking hard it was, but I should not have been allowed to be an Army Ranger unless I passed the same standards, of which physically there were certain things I just couldn't do.
Yeah.
And I didn't cry about that. That was a fact. And that's why they're elite units, because not everybody can do it. Now, when it came to my litigation skills and legal skills, I thought that I was the tip of the spear when it came to that. But look, I wasn't passing the most difficult land nav tests. It just wasn't happening. I hated that stuff. I hate it to this day. And the standard should not have been changed for me or for anybody else.
Well, it'll be interesting to see what happens with Hegseth and Trump. My personal opinion is there's probably going to be a lot of good things that happen. There's going to be some things that I think are probably not great things too. But
100%.
We'll see what happens in the next 4 years. All right, good pre-show topic. Let's get into today's real topic. We're going to talk about some military rules of evidence. We did a show on that earlier that was wildly popular. In fact, fact, we won't name the organization, but I think somebody actually called you and asked you if they could kind of use our discussion on the rules that you did previously as a teaching tool for their folks. And so that was great. We promised folks that we would do some additional, talk about some additional rules and provisions, and that's exactly what we're going to do today, right?
Yeah, no, I'm excited. And so for today, we're going to kind of cover the wave tops of MRE 608, Alpha, Bravo, and Charlie. Now, listen, Matt, there's no way that we're going to be able to cover the depths of these rules because, like most rules of evidence, there are depth there. There is depth there. But I wanted to cover these rules because if you're a defense lawyer, whether you're an area defense counsel, a regional defense counsel, a trial defense counsel, and you don't have these rules mastered, you're going to have problems. And really what that means is your clients are going to have problems. And so understanding the inside outs of these rules is vital to your success as a defense lawyer. And I just see too many young counsel mess this up. And it's just one of the things you cannot mess up because impeachment, attacking the credibility of the government's case, man, that's the heartbeat. That's the blood in the veins of a defense case. So if you can't do it, it's a problem.
Before you get into the rule or rules that we're going to discuss today, what does your gut tell you are the number of things you have to absolutely know when it comes to evidence? And we're not going to name them, but just if you had to say, okay, is it 10 things? Is it 20 things? Is it 50? Is it 5? What's the number to the things that you really have to know well to effectively represent your client or represent the government in the courtroom?
I think that you have to know the following like you know the back of your own hand. And that starts with relevance, 401, 402, 403, and then, of course, to some extent, 404B, which bleeds into character evidence and other prior acts, which really does all come down to the basic rule of relevancy. I think you've got to understand hearsay exceptionally well. You've got to understand how, on cross-examination, the exclusions and exceptions can help you as the defense lawyer admit something that otherwise may not be admissible. I think you have to understand foundation and authentication so that you know how to admit evidence under pressure in a courtroom with all the eyes on you, and you need to understand what questions and foundation you need to ask so that you can get the evidence you need admitted. I think that you've got to understand the rules of impeachment. I think you've got to understand your 608, I think it's the 609, the 613. You've got to understand case law's interpretation of impeachment. So impeachment via contradiction, impeachment via omission. You've got to understand when to impeach versus when to refresh recollection. And then I think on top of that, the best evidence rule is something you've got to have a fundamental understanding of, because that can also help you overcome some barriers and also make some objections that the other side's probably not prepared for. So at a baseline, I tell people that's what you need to know. And
so
then,
probably 6 or 7 things, and obviously each one of those has many, many components to them, but 6 or 7 things with respect to the rules of evidence that you really have to have mastered.
Correct. And then there's the 412s and stuff, but I think when you're talking about trial work, you've got to master those and not just know them or think you know them. You got to master them. You know, Matt, I told our one of our associates, Dominic, who joined us in the United States Marine Corps recently, I said, listen, Dom, I still write all my cross questions out and finish all my preparation 3 days before trial because I still practice for 2 straight days before trial. I've been doing this for a long time. And that's because you have to remain great. You have to do that. So those are the things you got to know, like you know the back of your hands.
All right. Well, good synopsis. And I think that will be helpful to our listeners as well. But what do you want to talk about today? We've got a rule of evidence, right?
Yep. Let's first start with 608 alpha. And this is reputation or opinion evidence. Now, everybody should understand that generally speaking, character evidence is not admissible. And MRE 404 alpha outlines that. And then you have your first exception under 404 Bravo, which is a primary tool used by the government typically, that says, well, certain prior acts are admissible as long as they're not there to show predisposition, right? In other words, they can't argue that because your guy committed a bad act on this day, he's guilty of what he's accused of. Now, another exception that is very seldom used by the defense counsel across the DOD comes with 608 alpha. And 608 alpha basically says that a witness's credibility may be attacked or supported by testimony about the witness's reputation for having a character for truthfulness or untruthfulness, or by testimony in the form of opinion about that character. So what this looks like in practicality is if you're a defense lawyer and you're trying a sexual assault case where your client's accused of a sex offense, and you find out that she's got a reputation for lying to folks, and maybe you talk to a couple witnesses that are like, we don't believe a word she said, and here's why. Well, you may want to consider putting those witnesses on your witness list and calling them for the specific purpose of offering an opinion before the fact finder that the alleged victim is in fact not honest. There's a couple benefits to that. First, it does allow you to you must lay a foundation for the opinion. And so that witness will take the stand and testify a little bit to how they know the alleged victim. They can't testify to specific acts of untruthfulness, but they can testify, well, I served with her in my unit for 3 years. We work together each and every single day. I've had an opportunity to know her well, both on a professional level where I see her, and we also socialize. We hang out with the same friend group. So the idea there's a relationship, they know one another, and this person certainly has more knowledge of the victim than the panel does. And then you ask the question, in your opinion, is the alleged victim honest? In my opinion, no, sir, she is not honest. So that by itself can be helpful. Some people argue that it's not all that helpful, but I disagree. I've seen it work well. Here's the second advantage to doing that. And this is, defense counsel, I'm giving you pearls here in the words of my great grandfather, right? I'm giving you pearls here. Okay. What this does is it sets the government up, because if they get on cross-examination, Matt, and they cross-examine this witness to attack the underlying opinion itself, well, guess what you get to do on redirect?
Bring in the actual facts that it's based on.
Perhaps bring on the actual facts that it's based on. And which each one of these rules, I'm going to give an example of how I've used it.
So the character witness says, I don't believe that the alleged victim is honest. If the prosecution at that point gets up and starts attacking that opinion, then it allows the door to be opened in some instances for defense counsel to come back in and say, okay, well, let's talk in more detail about why you have that opinion. Is that right?
Absolutely correct. Because
maybe I should be a trial lawyer.
You have the right to rehabilitate your witness, or you have the right to rehabilitate the foundation of the opinion. Because if the prosecutor is going to make it sound like the opinion's not valid or it's questionable or suspect, you then have the right to say, no, it's not, and here's why. I used this in Norfolk, Virginia, about 4.5 to 5 years ago in a trial in front of Judge Larson, who's one of the best military judges in the country. And this was a Navy sexual assault case. My client was a decorated Navy diver who, by the way, that unit was the most physically fit unit I had ever seen, and that includes some of our special operations guys. And so our investigator finds this witness who had worked with the alleged victim in the same office with her for like 5 years. She was the admin specialist to that unit, and they had actually had a personal relationship. They had, gone out on a date or two, hung out, drank beer together. And what we learned was this victim had accused this guy of sexual assault as well. And so I couldn't put into evidence the prior sexual assault allegation. I didn't quite have enough to get there before anybody listens to this and goes, well, there's ways to do that. I know there are ways to do that. Take me at my word. We didn't have quite what we needed to elicit it substantively. So I put him up there, and he's this big, ripped sailor. I mean,
this is the character.
This is the character witness, and the kind of character witness you want. I mean, a presence. And he gets up there and he says, he talks about how he knows her and says, in my opinion, she's not honest. Trial counsel gets up and just attacks this guy relentlessly about how they went on some dates and she broke it off and he was upset about this and all this kind of stuff. He had an axe to grind, and she didn't process his evaluation properly, and it led to a delay, and he didn't like her because of that. I get up on redirect and I say, Mr. Sailor, Mr. Petty Officer, why is she not honest? And he looks at the panel with tears in his eyes. He goes, and his lip quivering. Now, this is a big, Navy diver, lip quivering. Sir, because she falsely accused me of sexual assault as well. They objected. Judge Larson says, nope, it's coming in.
Yeah.
That panel deliberated for about 45 minutes. until they came back
So
with a
how
full acquittal.
often does the prosecution step into that trap? Because I would assume the more senior folks who know what they're doing are smart enough not to get set up for that, and they let the guy give his opinion or gal give their opinion, and they move on to the next thing. How often do you see it happen where they stub their toe on it?
More often than it should happen.
Really?
I think I'll leave it at that. More often than I think it should happen.
Yeah.
So
can you predict who's gonna fall? I say fall for. Can you predict who's gonna make a bad judgment call on that from a prosecution, or not really?
Only from the prosecutor's preparation. If the prosecutor's thorough and has interviewed all of our witnesses and finds out this is out there, the chances of them opening the door are slim. But I've also had folks do it without even knowing the rule. Right? They know that the bad information's there and they do it anyway. So they just don't quite understand because they think that that's barred by specific acts, but it's not. The specific act reference only applies under 608 alpha to direct and not redirect.
Yeah.
So
very interesting.
It's a unique way to accomplish what you need to, and those things can make a difference at trial.
Yeah. Heck yeah. Okay.
The second rule that we're going to talk about is 608 Bravo. 608 Bravo is a wonderful tool, defense counsel, to use that many of you do not use. And you need to start using it, guys and gals, because it is vital and it is another area of attack. So 608 Bravo is called specific instances of conduct. Except for a criminal conviction under Military Rule of Evidence 609, extrinsic evidence is not admissible to prove specific instances of a witness's conduct in order to attack or support the witness's character for truthfulness. In other words, if you have an alleged victim on cross-examination, okay, you cannot just go up there and use extrinsic evidence to attack her on prior acts of untruthfulness, okay? But the second sentence is the most important. The military judge may, on cross-examination, allow them to be inquired into, them being the specific acts, if they are probative of the character for truthfulness or untruthfulness. So 404 Alpha says you cannot say that somebody is a bad person because they've committed bad prior acts. 608 Bravo says, well, hold on. If it has to do with the credibility of a witness, then they may be inquired into those specific acts on cross-examination, but you cannot use extrinsic evidence to prove it up. A lot of times defense counsel think that if I don't have the extrinsic evidence, then what difference does it make? That is wrong. Your job on cross-examination is to tell a story. That's your job, folks. Your job is to tell a narrative that is common sense, believable. And so what this means is if you have specific instances in a sexual assault case where the alleged victim has committed untruthful acts in the past, you can cross-examine her or him on those untruthful acts, but you are stuck with the answer. You're also going to have to articulate to the judge how it does impact her credibility and then why it's not inadmissible under 403. So here's where I've done it successfully in the past. I had an Air Force case where I was defending a decorated Air Force E9 NCO. Case got some media attention, and it was a big case earlier on in my career. And one of the alleged victims in that case was an airman who had been given no less than 6 counselings for being untruthful to her chain of command. That she showed up late to formation. Air Force doesn't call it formation, but she showed up late and said that it was in fact because she was sick. But her battle buddy next to her then told her chain of command no, it was because she was out partying till 5 o'clock in the morning. And here's the text message where she said, "Hey, I'm going to be late. I'm still hungover." She had lied about some other issues about where she was at certain times. She had lied about a number of different things. The specifics were kind of diverse, but bottom line is we had her in about 6 or 7 different specific acts of untruthfulness. Okay. She had lied about her ex and had said that he had come and taken the baby after the divorce when in fact he never did.
So there was plenty there.
A lot of that stuff. So I systematically went through in front of the panel every single one of these acts with her. And she said no to the overwhelming majority of them. And I was stuck with the answer. But you could tell She got very angry.
She wasn't dishonest.
Said, no, sir, that's not exactly how it happened. No, sir, my NCO just was out to get me.
Yeah.
And the panel looked at this, and they had to have thought to themselves, okay, there's a lot going on with this airman here. There's a lot going on here, and we don't really trust her.
Yeah.
And a few of them she did admit. A few of them she said, yes, that's true. Or she would equivocate and say, well, I didn't necessarily lie, but I think one of the answers was like, I didn't necessarily lie, but yes, I wasn't as honest as I should have been. Listen, I don't care what her answer is. Does not make a difference, defense counsel. The narrative matters. And in that particular case, the government made a mistake and they objected to the line of questions in front of the military judge. And that allowed me to argue my position in front of the panel.
Oh, really?
Where I got to say, Your Honor, I have a good faith basis for these questions. The good faith basis comes from these counselings. I had the counselings in my hand. So the panel saw that I wasn't just making this up. And when I was crossing her, I was crossing with the counselings right there, and I was shifting pages.
Does the theatrics of it sometimes mean more than the answer, right?
Absolutely.
Yeah.
Now, you're stuck with the answer. I couldn't then admit, in most circumstances, there are some limited exceptions that are beyond the scope of today's
But you don't
call.
need. You don't need to.
You don't need. And then
how often do you have multiple instances of untruthfulness? Like that one's obviously a dream case where you've got 6 or 7, but how often do you have one versus multiple?
Oh, listen, I've used this rule in probably 70% of my sexual assault cases as a defense counsel.
And how that's interesting. And then how dishonest does it have to be? Like, let's say I lied to my kid about Santa Claus. You can't bring that kind of stuff in, right?
No.
It has to be something that has some meat to it, does it not?
Correct. You've got to still overcome the 403 barrier, right? And the judge still has to say, okay, the probative value here is higher than the prejudicial impact. So it's typically got to be something that really clearly impacts the credibility of the witness. And they're out there, guys, okay? They are out there. Good investigators. The last one, and I know we're running short on time, is 608 Charlie, evidence of bias. And, Matt, quite frankly, we could have an entire episode on 608 Charlie because it is the defense counsel's best friend. It allows you to admit into evidence facts that show the witness has a motive to fabricate, facts that show the witness is biased against your client. And it says here, bias, prejudice, or any motive to misrepresent may be shown to impeach the witness either by examination of the witness or evidence otherwise adduced. Unlike 608 Alpha and Bravo, for 608 Charlie, you can absolutely use extrinsic evidence. And so a good example of evidence of bias was I had a court-martial recently where my client was accused by his soon-to-be ex-wife of sexual assault. Well, we had a bunch of text messages where she said, if you don't agree to my terms of the divorce, if you don't stop trying to fight for custody, I'm going to accuse you of sexual assault because you're a piece of shit. You don't deserve to see our children. I don't want you around them. I'm not going to let you have any impact on our daughter's life and all this kind of stuff. So the idea there was we have a clear mindset of the alleged victim to show that she's really angry that he was contesting custody. That is a motive to misrepresent, okay? That is a motive to misrepresent. I'm going to get my kids, and if I have to falsely accuse you of sexual assault to help me do that, that's what I'm going to do.
Right.
I admitted into evidence the entire text message strain between these two about their children. And the government objected continuously to hearsay. And I argued this is not for the truth of the matter asserted. We do not think he's a bad father. We do not think he's full of shit. We do not think he's a scumbag. This shows her mindset and why she is angry and why she's making the complaints.
Yeah.
And it all came in. And I won that case.
Yeah.
And so
that motive to fabricate is huge. I remember asking you and Mickey in another podcast if you could have one thing go your way,
right,
what would it be? And it's a motive to fabricate.
And defense counsel, don't be afraid to admit evidence with the alleged victim on the stand. I know some of you guys are taught, be careful about that. You may not be. Practice and admit the evidence with the alleged victim on the stand. Don't be afraid of that. Because if you practice and you know your rules, you can do it. You don't have to just admit evidence through other witnesses.
That's a good point.
I've won cases because I've gone into trial with text messages like that, and my co-counsel, who was assigned military counsel, oh, that's risky. What if she does this or what? Good. Let her do it.
Yeah.
All it's going to do is hurt her credibility. At the end of the day, if you have enough evidence to show that it is in fact admissible, right, then don't worry about what she's going to say so much, especially with text messages. That's your name at the top of the text message. Yes, your number is 609, whatever. That's correct. You had communications via text messages with your ex-husband. You had those communications on 3 November 2022. Yes, I did. Do you recognize these messages? Yes, I do. It's simple, folks. Don't be afraid of it, because
that's a good practice point too.
Your best chance to win your case is during cross-examination of the alleged victim. It's the single most important moment in 95% of sexual assault cases. So that's 608 Alpha, Bravo, and Charlie. Those are the wave tops. Use it, know it, and if you have questions about it, you can call us. You have my word. A member of my team or myself will help you, because quite frankly, right now, there's far too many of our young service members going to jail that should not be there. And that's heartbreaking to think about. And this is the pressure that is on the shoulders of a defense counsel.
You guys talk about the rules of evidence a lot. Like, I hear you guys in the office talking about them a lot, and sometimes it goes your way and sometimes it doesn't. And sometimes you're angry that the judge maybe ruled in a way that you feel they shouldn't have. But the point is, they're really, really important.
Oh, yeah.
Yeah.
Yeah. I mean, it's, I would say being able to tell a story is maybe the number one most important trait of a trial lawyer. And then I would say number 2 is you got to know your rules.
Yeah. Well, I'm going to plug our YouTube channel only because we put these episodes on there. And I know that the first one we did on the rules of evidence was really well received. But if you're a listener to this show and you like these kinds of episodes where Rob or Mickey or somebody else talks about rules of evidence or practice tips, please let us know in the comment section, because we'd like to get some feedback from you on the types of information you'd like to hear in the shows. We're obviously still always going to do a variety, but if you like this, if you find it helpful, please put some comments in and other things that you'd like to hear Rob cover, or Mickey or Dan, and we'll try to do that for you. But great episode, Robert. You obviously know your stuff in this area. I'm quite impressed myself, and that's not easy to do, as you know. But great to have everybody with us today. Until next time, signing off on the Military Justice Today podcast. It's Matt and Rob. Take care, everybody, and be safe.
Thanks for listening to the Military Justice Today podcast with your hosts, Robert Capovilla and Mickey Williams. This show was made possible in part by the law firm of Capovilla and Williams. For more information or to listen to more episodes, visit militaryjusticetoday.com.